I would be speaking today on the willful defaulter and the entire framework which is there under the RBI guidelines. Now, just to give a little, this is the topic where a lot of people first just get a little confused, if I may say so, in terms of a willful defaulter. I know this is all over these days, and especially with the big defaulters which are there and the big promoters which have been defaulted on huge loans. And there is a lot of thing going on in terms of getting an extradition like the Vijay Mallya, and you have the Nirav Modi, and you have Mr. Choksi, and etc. And the list goes on. So this entire concept of willful defaulter was introduced by RBI so as to curb the entire default which takes place in the banking system. So I'll just broadly say what the topics I would want to cover at this session would be. First, of course, I would be giving a little brief on what exactly is the background on the willful defaulter. I would then go ahead with the key terms which are defined under the RBI Master Circular of 2015. What is your events which constitute a willful defaulter? Then a little bit of mechanism on how a willful defaulter is to be categorized. What is the position of a guarantor under the RBI circular? What are your consequences of being declared as a willful defaulter, which also includes your criminal actions? Thereafter, it is I would also try to throw some light on a non-cooperative borrower under an RBI and how a little different from a willful defaulter. Then again, a little bit on the RBI circular on the fraud, coupled with the judgments which have been there in the last couple of years in terms of the fraud and the natural justice circulars. Then, of course, then I would also be saying what is the consequence of a willful defaulter versus a fraud. Then another interesting concept is the publication of photographs in the newspapers for the willful defaulters. Then taking you through some judgments on the willful defaulter. And lastly, what are the safeguards which the RBI and the government has in place for the willful defaulter and for the fraud-related borrowers? So, beginning with the background first. So, basically, RBI issues these master circulars from time to time under various heads. So, let it be the banking related in terms of your transaction, in terms of the loans given. Now, same way, the RBI Master Circular also deals with the aspect of the willful defaulter, and it gives a benchmark to a bank to how to categorize a willful defaulter and what is the process to be followed. And this is applicable to all the banks. So this first started sometime in '94 when the RBI announced that they need to alert certain banks and the institutions and basically put them on a guard, which is to identify a willful defaulter at the outset, because there are a lot of lendings which were happening. So certain mechanisms were put in place. Initially, the loan amount which were to be to identify as a willful defaulter was 1 crore. This definition was then subsequently revised, and in 2002, the threshold was reduced to 25 lakhs and above. Now, there have been several modifications time to time, as I said, because this master circular usually is issued of July of every year. In case of a willful defaulter, it was 2013 and then 2015, where the circular as it stands today, which actually decides the mechanism of declaring a willful defaulter. Now, a little key terms which have been defined under the master circular of 2015. Now, a lender, who's a lender? Now, a lender is your bank to anywhere your amount is due, and it arises out of any banking transaction. Now, very interestingly, it also includes your off-balance sheet transactions, which is your guarantees and letters of credit. Letters of credit, I would say that it was in some news in the last 3-4 years for a few of the companies, and the entire fiasco which happened in terms of the banks and the PNB. So this was onto the news. So the willful defaulter circular also takes care of this particular transaction of your guarantees and off-market transactions, as they are called. Now, then coming to unit. A unit being basically a company which includes your individuals and your juristic persons who would be coming who would be coming under the definition of unit. Third important term, which is I think the crux of the entire issue of a willful defaulter when it comes to the circular, it is your siphoning of funds. Now, what is siphoning of funds? We may have siphoning and diversion again just used and saying, yes, this gentleman, this borrower has siphoned, this X company, X borrower has diverted the funds. So what exactly is siphoning of funds? Now, your siphoning of funds is basically any funds which are borrowed from a particular bank and they are in that sense used for a purpose which is actually detrimental to the financial health of a particular entity. Now, one may say that if I am using a particular money for a particular transaction for a particular company, and if whether it's my group company, so what is wrong? I am still doing it for the benefit of my company. But unfortunately, the willful defaulter mechanism doesn't allow it, and it becomes an identification of a willful defaulter. Now, another on siphoning of funds and in diversion, there was an interesting judgment a year back in the Amrapali in Chatterjee's case, where the Supreme Court actually had defined this siphoning of and diversion of funds, where somewhere they also went in to say, and of course that was followed in Anuj Jain's judgment in the Supreme Court, where they said that these aspects are also to be looked at from the banker's perspective. It is not always that once the funds are given, the bank in that sense will take a back seat and they will say that yes, the funds were given and now you've siphoned off. But there has got to be a periodic check and diligence even from the bank's aspect. So then coming to, of course, diversion. Your diversion in that sense has been clearly defined under the circular. Now, what are your instances of diversion of funds? So let's say if a company has been taking a short-term capital funds and you're using your short-term capital for a long-term purpose, which is not in terms of your sanction. So let's say a borrower entity takes it for a short-term capital loan. That's your purpose of the loan for a particular thing, but you're actually using it not in conformity with your sanction letter. Second is you deploy your funds and you creation of those assets, and for the assets which are not again in terms of what the loan was sanctioned. Again, coupled with merging with your first point, that what exactly were your terms of the sanction. So you're not dehouse the sanction, you are doing everything which is not mentioned in your sanction and doing something which is clearly contrary to your agreement, your loan agreement and your sanction letter. Third, which is the most common aspect of diversion, is to be seen by the banks, is your when you transfer your funds to the subsidiaries and group companies. Now, this in reality and in practical terms, this is where the bank actually starts feeling and they start analyzing in terms of that you're starting diverting the funds because it is going to your group companies and subsidiaries. Another fourth point is routing of funds. Again, I would say routing and transferring to subsidiaries again involves the major criteria I have seen in my experience in terms of the willful defaulter and dealing with the banks, that these are the couple of points which actually amounts to diversion, and the banks take a very strict view in terms of routing of funds. So what do you mean by routing of funds to any other banks or consortium? So let's say we are an individual bank. I'm a borrower and the borrower has an individual bank who's dealing with a particular loan sanction in terms of working capital, in terms of your other facilities which are enjoyed. Now, slowly the company and the borrower is growing. He, of course, then enters into another transaction with another bank, 3, 4, 5 banks together, and there is a consortium which then forms. Now, the consortium says that with an A bank, you need to deposit your particular income of the particular company where you are doing that, where you have a major account. But what the borrower does in this case is, he's not actually transferring the funds in that particular event, and he is routing it through some other account, which is a sixth, which is not even in terms of the not in terms of your consortium agreement. Of course, this is needless to say that this is without the permission of the lender, which of course no lender who's working in the consortium will ever do. Lastly, investment in other companies by acquiring your equities without the approval of the lenders, and the other fact being a shortfall in your funds which are dispersed and then your difference is not accounted for. Now, what are your events which are constituting a willful default? So the borrower defaults, he says, despite having the capacity to repay his dues. So he has the funds, but he is not willing to pay the particular bank. The borrower defaults and has not used the money for the specific purpose for the loan and has diverted the funds, as I explained earlier, that what is in terms of diversion. The borrower has siphoned off the funds, and today the money is not available with him, whether in terms of cash or whether in terms of the asset. Again, siphoned off, as I explained in the earlier part. These are the two important points of diversion and siphoning off. Fourth being, the borrower defaults and has disposed of the assets given as security without informing the lender. So if I take a loan and the loan is in that sense secured by way of a particular asset, and without informing the lender, I just dispose it off by whatever means. Fifth point, which is very important and it's very crucial, I would say, is that the banks and the RBI is also very clear on this, that the identification of a particular defaulter is got to be seen with his track record, and it is not to be based on an isolated transaction. So when I say isolated transaction or incidents, there could be situations where there is a justification of, let's say, a company actually putting the money into the subsidiaries because the subsidiary in the group company in that sense is interlinked with the holding company and is giving some kind of services. So if that is justified, there could be a situation where the banks and the RBI takes a little, I would not say lenient, I would not use the word lenient, because banks go strictly by this language and they'll say, sorry, it has gone to the company, it has gone to the group company, and it is a willful default. So there are situations where the banks just would not, kind of listen to you and they would just declare you. But there are instances also when there is a place from the company where they are able to justify this particular thing. And of course, the track record is again a very crucial aspect. So a company and a borrower and a promoter may have crores which are outstanding, but he has, in that sense, never defaulted on a very periodic basis. But there could be defaults which has occurred out of the market scenario, and it is a situation where he wants to possibly pay, but it is the market scenario or his business model which is actually not doing well. That's the last point which I have mentioned, is the default is intentional, deliberate, and calculated. Now, this is all comes in terms of your motive, that all these three things, ingredients are met, and there the willful default will kick in by the banks. I will explain intentional, deliberate, and calculated in the next slides in terms of a judgment of the Bombay High Court. Now, what is your mechanism to declare a willful defaulter? Just try to make it a little simpler version instead of just explaining how the process goes. So, and of course, as I mentioned there, it's the Jar developers case where the Supreme Court actually embodied certain principles. So, just to take a little deviation from and explain the background to all the viewers. So in 2013, as I said, there was a master circular on the willful defaulters, which actually had given this mechanism. And there was a twofold mechanism where there's identification, then the borrower gets a show cause notice, there's 15 days time, there is an order. After the order, there is a review committee with a hearing. Now, unfortunately, in the 2015 circular, the RBI in its wisdom or comments from the stakeholders removed the last leg of the review committee and giving you a hearing. So the situation arose that yes, you will be given a show cause notice, you will be given a hearing, you can file your reply. After that, there is an order, but you will not be able to actually submit any further submissions once the order goes to a review committee. So of course, Supreme Court in Jar developers year 2 years back had dealt and was dealing with actually two issues. One is the major issue of whether lawyers can represent in the in-house committee of these willful defaulter proceedings. So Justice Nariman was of the view that this cannot happen because it is a proceeding where it is not, of course, judicial in nature, and it is more for a borrower or a director to explain the incidence of a willful defaulter. Now, of course, there were arguments in the earlier cases of the Kingfisher and the various other promoters and the companies where they said that they went right up to the Supreme Court to decide this issue, whether a lawyer could appear or not appear. But Jar developers settles the issue that the lawyer cannot appear before the committee. And the JHA developers also is important in the case because it adopts the 2013 mechanism into the 2015 mechanism. Now, what is that mechanism? First, there is a committee which is called the Identification of First Committee, as you may call it. They are basically your executive directors of the bank, which is your general manager and the DGM, who examines the evidence of your willful default. Once that happens, there is a show cause notice to the borrower, and to be asking that why you should not be declared as a willful defaulter based on the evidence what the first committee or the identification committee has come to a conclusion. Now, here again, the show cause notice should be documented with proper evidence and what exactly is the first committee or the identification committee relying upon. Again, there have been plethora of judgments where people have actually challenged this particular aspect of saying that I have not got the requisite evidence, on what basis I have been declared, so on and so forth. So the ideal is that the bank gives you all the evidence in this aspect. Thereafter, a borrower usually gets 15 days to file a response to this particular show cause notice and can rely upon certain other documents if it be so. Thereafter, there is an order which is passed, because then the show cause goes to your identification first committee, where they have a look at all your submissions, and they would see that if they want to call you for a hearing, not call you for a hearing, and thereafter, of course, document on submissions of what you have done. They would then go ahead and either declare you as a willful defaulter or say that yes, we are satisfied that your case does not fit into the mechanism of a willful default. In case there is an identification, the order is passed, the order has to be given to the borrower within an X period of time after they have reviewed. Thereafter, your order will then get reviewed by a review committee. Now, who is this review committee? It is basically your top notch of the banks, whether it is your senior officials, your MD, and the chairman of the bank, where this order will be then reviewed by them. Again, you would have a chance, because of now Justice Nariman saying in JHA developers that you would get a remedy even before the review committee, and you would have the opportunity to deal with representation of facts and your law, everything, even before the review committee. Thereafter, there is a reasoned order which is passed by the review committee. Why am I stressing on the point of a reasoned order? Is because, again, there are situations where the companies and the borrowers actually challenge this particular aspect before the appropriate forums and courts to say that we have not actually been heard properly, or there is no reasoning given on why we have been declared as a willful defaulter. Hence, it becomes imperative for the banks to give, at least at the review committee also, to give a very reasoned order, giving in the instances on why they are declaring a borrower / promoter as a willful defaulter. Now, another guarantors are all over these days in terms of your IBC proceedings and your guarantors in various other proceedings. So even willful defaulter in that sense doesn't make any sympathy, if I may say, for the guarantor. The position of guarantors is equally bad in terms of a willful defaulter, because as we are aware that a guarantee is coextensive with your so the liability of the guarantor will become immediate if the bank has made a claim. Now, this happened in 2014, where the RBI in its wisdom said that even the guarantors and the group companies who have given guarantees, let's say the promoters or the group companies who have given guarantees, even they should come in the ambit of a willful defaulter. Now, an important aspect is that this treatment was only to apply prospectively and not in terms of guarantees were taken prior to this circular. Thankfully, that was clarified by RBI. Otherwise, possibly could have led to another series of litigations by various guarantors and corporate guarantors. Now, what are your consequences? We all say, okay, I'm identified as a willful defaulter. I have the order has been passed, and of course subject to challenge and etc. But what are my consequences on what will happen that if I am declared? What am I looking at? So what you're looking out at is this: you will not be granted any facilities by banks and financial institutions. Where there is an exact charge of or an identification of a siphoning, of a diversion, of your misrepresentation, your accounts have been falsified. There are cases where, of course, you will not be able to float new ventures for the next 5 years. But what follows from this is there will be immediate proceedings which are also initiated, let's say for cheating, for dishonest, for criminal breach of trust. There will be foreclosure, there will be recovery of all these for the loans. And another aspect is that the banks actually go ahead and also ask for a change of management of the defaulting unit. Now, they also see at scenarios where the banks have already lent to a particular entity. So they say that there should be a covenant in the loan agreement that in case we have given certain funds to a particular company, and if there is a person who's been declared a willful defaulter, he in that either is not to be inducted in that board or he's supposed to make an immediate resignation. Otherwise, the bank in that sense would not be able to further fund that particular company. So that is how the banks would and a willful defaulter would be able to not be able to do these particular actions. SEBI now let's say only or consequence of a willful defaulter is not only of saying not to open and not to get fresh funding or I cannot open new ventures. SEBI in that sense also puts restrictions on this particular when it's a willful default and is declared. Now that is of course raising funds by a public issue of your equity, debt and preference shares. However, SEBI has left a little window where the promoters and directors who have been declared, they can raise of course their money in terms of the private placement, which is not to be then disclosed to the public. But in this case, SEBI has been very conscious of this fact that at the same time, if they are giving a leeway to a defaulter, but it would require really rigorous disclosures. I'm not getting into various disclosures because that's another separate a session on what disclosures in terms of SEBI, because they've got a whole lot of disclosures. What is also is done is that they would be barred or would be restrained from entering into a transaction where there is a public announcement to be made. So SEBI lists down certain aspects where you're supposed to make a public disclosure of certain things. So of course a willful defaulter cannot do that. Now the only exception again being if there is a hostile takeover of that particular company. There SEBI makes a little leeway, but again, as I said, there are really rigorous disclosures and things from SEBI where they are very cautious of the fact that a defaulter cannot actually come back and take the company. But exception being, as I said, if there is a hostile takeover. Lastly, which is again in terms of coming to the IBC, is that let's say a company and a promoter or directors declared a willful defaulter. He'll say, okay, I may not get any loans, I may not do anything. And SEBI also imposed restrictions. So why don't I go and take a company which is now undergoing an insolvency process under the Insolvency Code 2016. But here again, the RBI and the various other authorities said, and even the IBC makes it clear under 29A that you cannot be a resolution applicant. Because if you are declared, it's like giving you a backdoor entry in a company. So the entire objective of that is that they don't want a defaulter to again come buy in a particular company and raise his stakes and come and then actually have, or you'll have a willful defaulter who's sitting on the board of the insolvent company. So that is the idea of not having that the willful defaulter cannot actually present a plan under 29A. This is another interesting concept. So we've dealt with what is a willful defaulter, what are your consequences, how is the mechanism. Now there are times of and this happens in a little practicality that people say, okay, he's a willful defaulter, he's a non-cooperative borrower, there's a fraud. But there are differential treatments to be done by the RBI and authorities. It's not that everything is just there. You just can't tell somebody, oh, you're a willful defaulter, or there is a fraud. There is a mechanism carved out by RBI and the way. So what's a non-cooperative borrower? On the first blush, everybody will say, oh, it's just like a willful defaulter. So to that, the answer is yes and no. But there is a difference. Now, a non-cooperative borrower is one who's basically not engaging constructively with the banks in terms of their repayments. and he does not assist the banks in the loan recovery process. And he's also denying the right of the bank to certain inspection of the particular documents which is given. Now, this has been carved out in the circular of December 2014 by the RBI. Of course, the cutoff in this case is for 50 million and above. It is also a non-cooperative borrower who will include the company and its promoters and its directors. And of course, the people who are in charge of day-to-day management of the company. Now, how does one classify? Like I explained the mechanism of a willful defaulter. So how do you define a non-cooperative borrower? Somewhat similar in terms of the willful defaulter, but slight variance. Now, of course, there are mechanisms which the bank, ideally the RBI in every circular, gives you a mechanism that the bank should have within their own their functioning of the banks, and there should be committees which are dealing with such aspects. Some have, some practically do not have, or they have it, but it's not in complete use. Now, again, here an important aspect is that an isolated instance cannot be treated as a non-cooperative borrower. If everybody recollect that I had actually explained that an isolated instance from the willful defaulter aspect should also not be considered. Same way, an isolated instance should not be termed as a non-cooperation from the borrower. Now, the decision to be classified again is in the similar lines, that there is to be the committee, which is the general manager, just like your willful defaulter, who decides this particular thing. And they will deal with all the evidence and etc. And in that case, they issue your show cause notice. And they also will issue the show cause notice to the promoters and the whole-time directors, of course, as managing from the day-to-day affairs. And they will call for submissions on this particular aspect of whether to classify you a non-cooperative borrower or no. Now, again, after the first committee is done, they will issue an order recording that, yes, we see on the evidence that, yes, you are declared as a non-cooperative borrower. Now, of course, a hearing in this case, as even the willful defaulter hearing says, that an opportunity should be given if the committee so requires. But I think in general perspective, banks, 99% of the times, they would give you the hearing in terms, because they would not want a subject of challenge going before the court and saying that they did not get an opportunity to present their case. That is in clear violations of the natural justice, which I'll be speaking in some time when it comes to the fraud aspect. So an opportunity is given to the borrower. He gets into for the personal hearing, and if at all, of course, the committee feels, and it is confirmed by a review committee that, yes, you are a non-cooperative borrower, and you are actually, if I may call it, a stonewalling of process from the aspect of not being able to provide certain information, or actually making it difficult, if I may put it, for the banks to actually recover. So in that case, the banks and your institutions then have to report it to the CRILIC, which is your central repository for these large credits. So these institutions which are formed by the RBI, it is a mechanism like the central repository, and then you have the CIBIL, where it is an open forum for all the banks to actually be in one place and then identify whether, and this would be very helpful in terms of when you have to, a bank or an institution actually has to give in a loan, or has to actually monitor on the loan aspect of various borrowers and promoters. So this mechanism gives advantage to the banks to know and assimilate information at one given place. So we dealt with willful defaulter, we dealt with what is a non-cooperative. Now, in the same line and breath is something on what RBI talks about, and there are master directions, a circular on the aspect of fraud. Now, there have been instances that the fraud circular was in place even much prior to 2013, 2014, and when we started from 2012. But as the time and as the situations in the banks started increasing, and we are all aware in the last 4, 5 years, 6 years or 7, 8 years, there have been that the NPAs have actually risen in the country, and there are being bank loans. Not taking away the fact that there were bank loans earlier, there were defaults earlier, and the defaults still continue even in the current scenario as I am speaking. So there have always been an aspect of the NPAs, which is really a problematic for the banking sector. And as I said, not now. This is a this is a stigma which is on for quite some time in our country. So if you see from the era of actually getting into the BIFR, after BIFR, there was, of course, then the SURFACE, then you have the RDDP Act. There have been various forums. Then RBI also came with somewhere in terms of your CDR, which is a debt restructuring, which they said. Then you had the SDR, and there were various other forums to actually carve this menace of NPAs. But I would say that personally that this worked to some extent, but to a larger extent, I don't think it solved the purpose of the NPAs. And hence, somewhere or the other, the IBC code and 2016, which was formed, which of course then got away with all these other restructuring mechanisms, because somewhere the stakeholders and the RBI felt that this was more in terms of evergreening a particular loan which was happening during the restructuring time. So now coming to the aspect of fraud. Now, what is the circular on fraud says? It is basically what the RBI is saying, that the moment the bank finds that there is something in the company after checking its records, that there is a possibility that this company may slip into the fraud account, they are supposed to take requisite from the particular and from the particular bank, and try to see that they will also caution the other banks who are dealing with a particular borrower. So let's say today, if I identify from a borrower's XYZ borrower's account that there are situations that there have been a lot of possibly cash transactions from that company. Now, I would see that this is a signal for me to identify from a banker's perspective, that I would identify and I would tell my other consortium lenders or of course the RBI, and say that I think, hold on, there is a problem here. I am noticing this from the borrower's aspect, and I think this should be reported. So it is an information which is an early detection and which is given to all the banks. So, and of course, this has come because of the various, the accounts which turned into fraud or slipped into defaulters by the various big promoters. So the RBI thought that it is prudent that we catch them at the inception itself. And even if we see slight deviation, everything should be informed. Now, what is basically fraud? That fraud is basically defined as per your Indian Penal Code. It is your misappropriation, it is a criminal breach of trust, there is manipulation of books of accounts, fictitious accounts, your unauthorized use of credit facilities, your cheating, your forgery, your fraudulent transactions which involve the foreign exchange too. Now, another mechanism of your fraud circular, there are two important aspects, which is called your early warning signals, it's the EWS, and what is a red flag account. Now, this RFA, I'll be terming it as RFA going forward. It is an important step because, as I said, it's a signal given from the bank perspective to all other bankers that, as I gave the example of cash transactions. So I am identifying it at the very first go, that why is this happening? Why is this company actually having so many cash transactions? Or why is it there has been withdrawals from the particular cash? So it is a suspicion of a fraudulent activity. I say suspicion. I'm using the word very carefully, as a suspicion of an early warning signal. Hence, it's been defined as an early warning from the RBI. Now, these signals immediately alert and put the banks on what eventually may turn out to be fraudulent. Let me stop here and say that it is not necessary that there is a suspicion, and there is actually when one bank realizes that no, it was only a suspicion and it's not that the account is fraudulent. But most of the times, yes, it eventually possibly will lead to fraudulent, but not always. Now, what is your threshold when it's from an EWS or declaring as a red flag account? It is for an exposure more than 500 billion. Now, whether it could be a sole banking or it could be under a multiple banking or a consortium, however the case may be. But then begs the question, what happens to the 500 million below? I mean, what do you do with that situation? It is that RBI says that you may form your own mechanism, internal mechanism to deal with such accounts. Now, I've indicated some illustrative list of what is an early warning signal. This is the list is quite exhaustive. I think there are around 50, 60 or 70 of such been identified of what is an early warning signal. So I've just tried to call out the major ones, which is, of course, your default in payment to your banks and your debtors and your statutory bodies. there are bouncing of high value checks and your value of RTGS when you make high value RTGS to unrelated parties. There has been frequent raids by an income tax authority or a central excise or GST, etc. There is an increase in unbilled revenue year after year. There is a change in scope of your project. So I take the loan from a particular aspect, but I am just changing my scope, maybe on a 6 month, 8 month, yearly, 2 yearly, and I keep on changing my scope of project. Inventory funds coming from other banks to liquidate the outstanding of the loan amount. So I take it from a particular bank, but I go to B and I say, let me just go and clear A. And I'm doing this scenario with various other banks. Another important thing is when your resignation of your key management takes place in the company and it becomes little frequent. Now, this actually will, when I say it's an early warning signal, but at the same time, it is very crucial because the bank will also immediately start noticing that why is this particular happening, and they would actually go ahead to the RBI, and possibly at times they go to various other authorities and caution them that there have been situations that this company is changing its management frequently, and let's keep it as an EWS for the moment. And I think we should then go ahead of mentioning it from a red flag accounts perspective. Your stock audit report. Now, these are audit reports which are taken in the companies, and your auditor and this has been highlighting it time and again, but the borrower or the entity is not actually taking it seriously, and this is time and again being mentioned in the report of declaring it from a red flag account. As I said, not routing your sale proceeds through the consortium, which takes you back to the willful defaulter, as I explained, not having it to your particular member and giving it to your other consortium or member which is not actually a part of your consortium. Your foreign bills, which are outstanding for a long time, even that is an EWS. Another important is where the banks usually have this, once the loan is given, they would also do a frequent inspection, when it comes to inspecting your godown or inspecting the goods. And one way or the other, the borrower makes some reasons and is not allowing the banks, because at the back end, he may be doing an XYZ thing, which is not actually in the health of this particular bank. And that's why he's, as I said, stonewalling the process, as it's mentioned in the non-cooperative borrower, and he's stonewalling this and not allowing the bank to come ahead and actually do the inspection, because he realizes that there is something which is not happening at his front. So hence he doesn't allow the banks to come and do the inspection. Now, early detection and reporting, as I said, that it's a quite effective way of preventing loan frauds in a particular thing, and any weakness which now at times it so happens from a bank's perspective that they may do their diligence, they may do everything which is good, and they give high exposures to the borrower entities, but it so happens at that time they are unable to figure out at that particular point of time, and it is possible that there could be something which is slipped out from their end while at the time when the loan is actually sanctioned. So RBI says, no worries, you have given the loan and you must have done your limited diligence, but you should be having frequent monitoring processes laid down from the bank, and you should actually have your checks and investigation on a very frequent basis. Of course, that will depend on the particular bank and your arrangement, that whether how frequent is this inspection. So it could be, of course, when it's a pre-sanction, when you do your diligence, it is the time of disbursement, it is your annual review when it happens. It also happens in terms of staff empowerment, so as to report to the fraud monitoring group. Now, this is an interesting issue when it comes to the staff empowerment. Now, what happens to the staff empowerment? So let's say from a bank. Now, I realize that there is chances of this account actually showing me the signs of an EWS and then eventually being a flagged account and then leading to the last example of declaring it a fraud. But I may be skeptic to actually go there and be a whistleblower and say that, oh yes, this is the account and this is where I'm coming from and this is what I have actually examined in this particular account. So the RBI says that you need to get this more culture within your banks and actually motivate such kind of early detection of the particular EWS or the red flag and the fraud related accounts. Of course, the auditors again have a big role to play in this aspect, because it's the basis on their opinion, and they say that they would be either identifying it as the fraud or not as a fraud account, or actually showing signs of an early warning signal and then leading to a red flag account. What the RBI also has done is that they have actually formed a central fraud registry where various banks, and this is a central mechanism only used for by the banks, where they will actually, it's a common database, if I may call it, for reporting and putting all your whether it's early warning signals and your red flag account related issues to all borrowers in one place. That actually helps the banks and the other institutions that before they lend to a particular individual or to a particular borrower entity who's connected with that borrower or a promoter, they would actually see that what is in terms of exposure, or whether in the last few years, have you ever been slipped into this EWS or a red flag account? And it will actually make their diligence process much more robust. What actually happens when you are actually declared a fraud is that you are ideally then leading up to a situation where all the investigative agencies would come, and the RBI asks the banks to actually take preemptive steps on, and without any delay. This has been very categorical in clear terms in the entire circular of fraud, that they say you've got to be immediate in this, because if you stop it at your early warning signal and your fraud, you could actually prevent other banks of losing their particular money, which end of the day is public money. So immediately the banks are advised to file certain complaints with the law enforcement agencies. This has been a little contentious issues which has been arising maybe from a couple of years, is after the fraud circular. Because what the fraud circular actually tells is that I identify an early warning signal, I report it to the RBI. The RBI then there would be a mechanism where there would be a report, a forensic report taken. There is a JLF meeting, assuming joint lenders forum meeting, which they have with all the banks, and then decide that yes, this entity or this borrower entity or the promoter is declared a fraud. But what a vital aspect which is missed in the fraud circular, and which is exactly the subject challenge of this, and which I also personally feel that this is clearly in violation of our natural justice, is that the banks would not give you an opportunity to come ahead and say that, yes, you have been declared a fraud. Can you please explain, just like how I explained in terms of a willful defaulter or a non-cooperative borrower. In this case, they are said that there is nothing doing. You have been declared, there was an EWS, you then went into the red flagged account, and eventually you were declared a fraud because of this particular. So there has been no exchange of information. It only says that we have declared you as fraud, but without hearing me. Hence the concept of natural justice and odi altrum partem, which is of course here the other side, the legal maxim. Now, interestingly, Telangana High Court was the one where, with this entire issue, in the judgment of Rajesh Agarwal, where this entire issue came up, and the High Court there felt that yes, this is something, it's a serious concern, because you are actually declaring somebody without giving him an opportunity, which is completely dehors the natural justice principles laid down even by the Supreme Court in various judgments. So how is it that the RBI can just say that yes, you have been declared as a fraud, we're not going to listen to you, and you are declared a fraud, period, and all the consequences and all your agencies will start following you without giving me an opportunity. Of course, this Rajesh Agarwal's judgment is pending before the Supreme Court. It will be interesting to see what eventually Supreme Court has actually going to deal, because the Supreme Court hasn't stayed this judgment. So as we speak, that yes, it still stands, but let's see what the Supreme Court in that sense will now deal in this particular matter. The second of the lines of judgment was the Apple sponge and power, where again the Delhi High Court observed that again it's an administrative decision, requires your principles of natural justice, and the High Court said that it's not it's not mentioning that the bank cannot declare you as a fraud account. They of course have the right to declare you, but the precursor to that being is that you need to give me an opportunity to actually come when it's an EWS, whether you are coming as a red flag account or eventually you're declaring me a fraud. It cannot be a one-side show to say that I have done my diligence, I have done my aspect, and you're not even asking me. And eventually, I am going to suffer when I say I am the borrower, the entity, or the promoter. So the repercussions are quite huge. So hence, the Delhi High Court said that this cannot be, and they state the particular the show cause notice issued by the bank in that particular case, and they said that the natural justice should be followed. Now, the entire validity in all these were also challenged in Kanta Devi and in Puneet Garg's case, which is the Anil Ambani's companies, where they have challenged this fraud circular again on the similar lines as explained above, that they say that there cannot be a unilateral situation where you are actually just declaring me a fraud without even hearing me. Of course, that is also still pending before the Delhi High Court. Now, I've tried to give what are your consequences, as I mentioned earlier, of a willful defaulter. Now, just doing a compare of a willful defaulter of the consequences of fraud. Now, the basic intent of both this, if I may put it very simply, is that you cannot get any bank finance and under any head of purpose. But the idea of fraud being this, that the early detection, which is very prevalent, and it will actually imply the other banks of not actually lending or stopping your particular funding once realizing that there is an EWS or RFA, which is a red flag account, being investigated, and they would stop it at the right time. So there's an early detection which happens, as far as the fraud is concerned. Now, of course, as I mentioned earlier, that as far as the fraud is concerned, they say that you have defaulted. Okay, your account is termed fraud. Now, you would be barred from 5 years from actually making the full payment of that defrauded amount. So one question is that, yes, I pay the money and then I get out of this particular thing. Yes, you may want to get out of this particular aspect of a fraud account. But what follows from this is that your investigative agencies have already gone ahead and filed certain complaints. So it's not that those complaints will just unilaterally get. They will actually, because it's a as explained in that, your crime in that sense is already committed. So the question of not going back from the crime, of course, there could be settlement and etc. That's a different aspect, and that's a different ball game altogether. But the situation is that complaints will still carry on. Now, when it also says in terms of asking from debarment of seeking additional funds or restructuring. Now, once your term, of course, I think the stigma in terms of a willful defaulter or a fraud, I think is by and large. The stigma of a fraud is more because fraud then leads to, as I said, you have your enforcement directive, you have the PMLA issues, your fugitive, and your CBI proceedings. All in that sense comes together. And the repercussions of fraud in that sense becomes much more as compared to only, and it really puts a stigma in the society of once being declared as a fraud account, because eventually, even after 5 years, you would be still looked up to say that, oh, your account was actually declared a fraud. So you'll always be looked up throughout, though the statutory says 5 years, but you'll be always looked up to say that your account was declared at a particular point of time of fraud, and there were multiple issues or red flags in your particular transactions with the banks. Now, another important, as I said at the start of the webinar, was in terms of publication of photographs of the willful defaulters. Again, this entire publication of photographs, I've personally also handled. And we've been in a lot of matters where this issue has arisen, whereas the willful defaulter and publication is concerned. Of course, in some cases, we've been successful enough to stay the particular order of the banks of not actually publishing photographs of the willful defaulter. So what does it do is that, so RBI, and it's all, there were a lot of issues which were going on in 2015 and 2014, where defaulters left, right and center. There were situations where they were photographs were being published. So the RBI thought in its wisdom that let's come out with a circular, and in 2016 they said that the lender institution should actually have again an internal mechanism where they should identify that in what cases do we actually publish a photograph of a willful defaulter, because the basic idea from the bank's perspective is name and shame that particular gentleman. Now, once there is a name and shame, of course, the promoter would come ahead and say that let's look at it from a closure aspect, or let's look at it from the OTS perspective, and they will try that tooth and nail of not actually having their photos published in your leading newspapers, which is actually a stigma on that particular individual and the entity. So, of course, the RBI says you form your policy, have your internal policy where you actually don't make it a routine. Do not make it a routine to publish each and every defaulter. There are huge loan defaulters and you would want to possibly publish them. There are possibility that there are loan defaulters, but it is not a default which is actually diversion or which is not actually siphoning off. So in that case, you may have a little lenient approach as far as the defaulters, which are the defaulters of a huge one, and actually there is diversion, siphoning off, ED, PMLA, etc. So keep that distinguishment between or not so genuine willful defaulter who's actually because of the economic situations is not being able to do, and the one who's actually been able to actually siphon off and divert the funds. Now, there was a judgment on Metsil exports in the Calcutta High Court, which had taken a very complete different view, and they said that no, sorry, this cannot be done. You cannot publish, the photographs, and this is absolutely taking away the rights from the borrower's perspective of under the constitution guarantee, and you're defaming him by publishing it in the newspapers. However, the DG Exim earlier and the Bombay High Court gave a different view, and they said that I think this mechanism of publication of photographs is either way there under the SURFACE rules, because under the SURFACE rules, once the property is actually there in the public and there is a default on that particular on the particular borrower, it gets published in the newspapers along with the borrowers. And there is a twofold aspect of why the Bombay High Court said that is, first, it cautions your defaulters in public at large, and secondly, it cautions those prospective buyers who may have offered the property. I think this was quite vital because it happens that I may not know possibly the company, but I know the face of that company, and I must have done a transaction with that particular property or the particular entity, or with like let's say it's a developer, and I must have taken a flat from that. But that will caution me that, oh, he is being termed, so I don't think I should be going ahead with my dealings with this particular entity. So eventually the Bombay High Court said that yes, you can go ahead and publish the photograph. This has also been upheld by the Supreme Court. Now, some really judgments, important on the willful defaulter is this was, I would say, the start of in the Ionic Metallics case in the Gujarat High Court. Because earlier, as I said, in the 2013 circular, that the circular was meant to be and applied to everybody and anybody in the company. So let's say it's the directors were not even involved in this particular transaction. Everybody is basically, as mentioned in the judgment, is that everybody is painted with the same brush. But that's not the case. So the Gujarat High Court, in its wisdom, actually declared it ultra vires and violative of your Article 19 of the Constitution only and only so far it is applicable to all directors. So the High Court in that sense said that it cannot be that all directors who are dealing with the default are supposed to be termed as a willful defaulter. Because you please have to understand that if you are declaring a director who's not even involved, let's say an independent director or a non-whole-time director or a nominee director, it is nowhere the case that he would be involved in this default because it has not happened with his consent or with his connivance. Now, that's another aspect which is there within a few judgments, that there are situations that a lot of the independent directors are also dragged in. But there are situations where the independent directors cannot actually wriggle out of their obligation because they were present at that particular meeting and they actually sanctioned with their open eyes this particular, of course, fraud, as we say, that it is not something which is unearthed at the time at the meetings. Of course, no independent director would be told everything on that particular transaction. But how the RBI and the banks will look at it, that yes, you were present and you did not object to it. So in that case, yes, we can held responsible. But the general rule will be that the nominee and independent directors, unless proven to the contrary, should not be made a part of the willful default. And of course, then it went on to strike down only with respect to applying the circular to all the directors of the company. The second of the series of judgment was in the Kotak Mahindra's case, where the High Court held that default by a party in complying with under the derivative transactions. If I take you back when I first started with on what exactly would be when I said about in terms of the lender definition under the circular, it also included the derivative and off-balance sheet transactions. So that's exactly what the Bombay High Court also says, and even the Supreme Court in Mahindra Bank's case. Now, this is the judgment which I was telling when I was telling in terms of that the default in Kailash Sara and IDBI Bank, the Honorable Bombay High Court actually took a very interesting view that it is not that a mere default is enough to declare a willful defaulter. So there is a default which has occurred, and then your default gets coupled with intentional, deliberate, calculative, which I have also said earlier, that these three things are very crucial for somebody coming under the definition of a willful default. So, as explaining, there could be two scenarios. When I am actually defaulting on a loan and I do not have the capacity to pay, but it is not that I do not wish to pay the bank, but it is because there are economic situations, like let's say the COVID situation. Now, the banks would be able to take this into consideration that, and of course, that the fact that there are COVID measures being taken by RBI time and again in circulars in the last 1 year or so, where they have actually given relief. So one may say that I have actually lost my thing because of COVID. Let's say it's a company which deals with services from a perspective who actually used to have more of physical appearances instead of having it online. So that industry, in that sense, would actually be able to take shelter and say that it is only a default which is there, and I am ready to rectify my default, but I have not willfully defaulted, and there is no motive of me taking the money and then forming my assets or diverting my money to some other companies. So I think this was a very crucial judgment in Kailash Sara, where Bombay High Court actually went and they of course said that this was in terms of a non-whole time and a non-promoter director, because he himself was able to show that he was not involved into the day-to-day affairs of the company. As I said in this, now the Jha developers, this was the case where I mentioned the two important crucial aspects were whether lawyers could appear before the committee, or it is only the people or the borrowers' end who will actually be a part of this thing. So of course, the Supreme Court in Justice Nariman said that lawyers cannot appear, and there has to be a dual mechanism, as explained in my mechanism slide, to be adopted, and actually delivering a reasoned order once you're declared as a willful defaulter. IBC versus willful defaulter. I think this has also been a little, because all the promoters and the companies would immediately after IBC, as they're aware that once there is a moratorium declared, once the company goes into IBC. So of course the promoters in this case, in Ayan Malik and State Bank, went and challenged it in a writ petition, challenging the bank's right of issuing the show cause notice and going ahead with the willful defaulter proceedings. But the Calcutta High Court here, in two questions which were framed. One is that whether the proceedings of willful defaulter vis-a-vis the company would continue, and second, or whether it would be hit by the moratorium. And second, what would happen to the directors of this particular company? Would the proceedings go on, or would the proceedings be under moratorium, under 14? So the Calcutta High Court very interestingly came down and said that as far as the company proceedings, that has to be stayed because it will clearly fall under the aspect of moratorium. But as far as the directors are concerned, they say that they cannot be actually claiming at par with the company, and the proceedings of the banks can easily continue against the directors of that company, and they are not going to get any kind of a shelter under Section 14 of the IBC. So that is how and I think rightly so, the banks, because that is the same situation which is arising in terms of the guarantors. They say that the guarantors cannot get any relief once the company goes into IBC, and of course these proceedings. So I think it is a decision which the Calcutta High Court has taken, taking it in terms of the as the law which is settled, that the director should not actually be escaping this particular moratorium, or rather not taking shelter under it. Now, again, the Calcutta High Court in very recently in Kejriwal mining also came down very heavily on borrowers and the companies actually challenging every aspect of the order which is passed by a Wilful Defaulter committee before High Courts. So the High Court in its wisdom said that please understand that in a writ jurisdiction, first and foremost, of course, your grounds are very limited, and it is only when there is a patent and a malified arbitrariness or a bias or an abuse of the committee, it is at that situations one should actually challenge the particular willful defaulter. Now, patent malified, arbitrariness, bias, abuse of process, there could be various instances. So I think this will purely depend on your facts and circumstances of every case, whether this would actually fall under it. But of course, you have a right to challenge it. That right to challenge the court doesn't take with it. But what the Calcutta High Court says is that you need to have it within these few parameters so as to come and challenge any order of before the High Court. Another interesting was, again by the Calcutta High Court, was in the Maheshwari Ispat's case, where it was held that, the willful defaulter, which is again discussed, does not make each and every person who's unable to pay or repay a particular loan, which does not make him a willful defaulter, as I explained, and which I think is the correct view to possibly take, that it could not mean that every default is a willful default. And there has to be, as I said, bad motive, your intention, calculative, etc. Now, what are the safeguards which usually are done with the willful defaulter? Just to sum up of what safeguards have been done as far as the willful defaulter. So under the banking regulation, the RBI issues directions for resolution of stress assets, where they also deal with how to deal with a stressed asset or with an account and vis-a-vis a willful defaulter. Your SARFAESI Act was also amended so as to include where there were 3 months of imprisonment if the borrower does not provide an asset details, and for the lender getting the possession of the mortgage property in 30 days. So it also happens that, this could also be a term of a non-cooperative borrower, because he's in that sense not providing, and he's stonewalling, as I said, the process of recovery from a bank. Your Companies Act 447, 448 also becomes applicable, because then the banks go and actually file FIRs and certain complaints under these particular sections. You also have 415, which is in cheating, and 403, which is a dishonest misappropriation of property. And usually, as I said, that the criminal action, the banks are usually forced to file complaints under these particular sections. Another safeguard which is there, which came after that and very recently, was the fugitive economic offender. Now, this was also passed because it all starts from, as I said, starts from your willful defaulter, then you would, whether it is a non-cooperation, and then you have been declared as an EWS, there's an early warning signal, a red flag account. From a red flag account, you move on to having complaints under the various enforcement agencies, CBI, ED, PMLA, everything kicks in. Now, with that, there is also one which is the fugitive economic offender. Now, in this case, of course, there is a mechanism, the inbuilt mechanism which is there, and how one has to be declared as a fugitive. It's not that we just, and as a layman, we could just say that, yes, he's a willful defaulter and he's a fugitive. No, they are two different things. A willful defaulter is in a particular mechanism under your RBI guidelines, and a fugitive is to be dealt with your director from your ED and in a particular PMLA code. So they are absolutely two different things. Rather, I would say a non-cooperative, defaulter, fraud, everything actually has a lot of difference and a lot of bifurcation. It can't be used at the same length and breadth. Another important thing which the government came is in terms of actually cautioning the public sector banks and obtaining a certified copy of the passport details. Now, of course, this is, I'm sure everybody is aware of where this is coming from and why this entire aspect of taking details of the passport came in, and why. Then, of course, it said that it's not at everybody, but somebody who has an exposure of more than 50 crores, the banks may in its wisdom, takes details of such a passport. Now, as I said, that even the IBC debars your willful defaulters of participating in your insolvency process. So that's about it. On a lighter note, this is that I'm not a willful defaulter, but I'm just not willing to pay out of my own pocket. So that's about it. So I have a question here which says that second slide stated that even the individual can be declared, but then mostly every aspect highlighted in reference to big business units. I have two questions. Whether an individual for non-commercial loan can be declared? Yes, it can be declared as a willful defaulter.
As we are discussing today about this topic, I just wanted to know your views. There has been a new bank or an entity that has been created to deal with the bad loans. So where does it actually fit into this whole legal aspect? That is the law that we are discussing today right now.
Sorry, I lost you in between. Can you just kindly repeat? I wasn't too clear.
Yes. Okay, sir. So this question is regarding the recent entity that was created in 2019 by government and the RBI to actually take over all these bad loans that the banks have. They are basically those are the loans that have been basically they have been actually declared as an NPA.
Right.
So now it has been now almost like 5 years. No, not 5 years. 2, 3 years, 4 years. So now I wanted to know where does this entity actually sits into this whole legal aspect of this default.
Yeah. So to answer that, I think you're talking about the bad bank, which is
yes.
So this bad bank. So this bad bank aspect. If you're asking my personal opinion on thing, I think I would have mixed views on this, whether it is good for the for the banking sector, because I think if you see in history, there has been a lot of from the RBI's perspective, there have been a lot of measures which have been coming. I think this is maybe again a step in the right direction to say that all your bad banks would get transferred. But if one has to go back and to answer your question, that whether if I've understood you correctly, is that whether the willful defaulter would again get assumed in these bad banks. But if you see in the fraud circular itself, that the RBI is very cautious of it, that that there are mechanisms where your loan gets assigned to a particular ARC and it is transferred to certain other entities. But the RBI in that sense is that your element of fraud and this does not go away, and you should ensure that even if you are packing everything and just transferring it to the bad bank or it may be to an ARC, but at your level of that fraud which has taken place, you should be very conscious of the fact that you are not only packing and just transferring the entire fraud loan account to some other ARC and putting it in his head and moving and doing your books or a favor in that sense and cleaning your books. So that's something which the RBI comes out very heavily on that. But as far as the bad bank is concerned, I am still have that mixed view that this is just in addition to what we already have. And it's not something which may or may not actually be in that sense favorable, because as I said, there have been so many instances where the RBI has been coming with this, and we're just coming up to another situation where this bad bank is formed. So it's only just clustering it again with another entity called the bad bank. But I think the real issue lies in the NPAs and stakeholders, and have to address that issue, and the banks need to address that instead of creating something else which may or may not actually help.